Dear student friends, you are aware that I am Dr. Rega Suryarao. Today, I wish to take up most important topic in English for the benefit of all law students right from first year LLB to final year LLB. In this lecture, I wish to enlighten you in brief family law 1 and 2 in general outline, laws, different branches of law, categories of law depending upon the purpose and nature, and prospects of legal studies and legal profession, and finally suggestions to enlighten your professional career. This topic is in English, need not be mentioned specifically because most of the topics, most of my videos are uploaded in English language only. Recently, at the request of my student friends of Telugu, I uploaded some lectures in Telugu. Out of 335 lectures reported so far, only 60 to 70 lectures are in Telugu media. The rest are in English only, absolutely English. To avoid confusion, recently I started uploading both English and Telugu immediately. Recently, first I am uploading in English, uploading in Telugu, then immediately in 1 or 2 days in English only. That all the titles of my lectures will be available in English also, English only, but some of them only Telugu. So, in this connection, I wish to tell you, suggest you, dear friends, I who those who are interested in watching my lectures and those who are looking forward to my video lectures are suggested to watch my lecture immediately as and when it is notified. If you spend 3 4 days, 1 hour in 3 to 4 days, you will be able to cover almost all my video lectures in course of time. Otherwise, it will not be possible for you to watch my lectures above 230. When once a candidate has watched all my videos so far, it may not be difficult for him to identify the correct answer in objective type judicial services examination, because so far I have uploaded the vital subjects prescribed for judicial services examination, namely CPC, CRPC, evidence, and IPC, IPC, CPC, CRPC, Evidence, Transfer of Property Act, Law of Contracts, Law of Torts, and Sale of Goods and Negotiable Instrument Act. So, most of in judicial officers exam, there will be around 15 to 20 main subjects containing some 20 to 25 enactments, and most of them, barring 1 or 2, I covered so far. When once the student has successfully completed watching of my videos uploaded so far, it will be very easy for him to get through the judicial officer's preliminary examination. If you are with your kind cooperation and encouragement, I will be able to complete the LLB subjects common to judicial services also. And if you God permits the strength of my health, I will be in a position to upload the lectures for judicial services, and I also prepare hard. I will work hard to deliver district judge examinations also. In this connection, I am collecting material and inquiring from reliable sources. Please acknowledge my lectures, and please respect my words, acknowledge my lectures, and trust my words, and enlighten your professional career. Today, I wish to speak to you on three aspects. Number one, family law 1 and 2. Number two, law and various kinds of law and different categories of law. Thirdly, legal studies, its legal studies and legal profession, its prospects and its prospects. These are the topics we have to discuss. How far our legal profession is enjoying supremacy, superiority over civil services, the so-called the greatest, topmost competitive exam I am going to enlighten in this particular lecture. Dear friends, family law. For the benefit of first year LLB first semester students, there are 5 subjects. I completed almost all the subjects except Family Law 1. Family Law 1, I covered only Hindu law, marriage, divorce, adoption, maintenance, minority, guardianship, that much. I did not cover Hindu law, I did not cover Hindu law joint family. I did not cover Hindu succession. I did not cover Muslim law, like this. So, this subject, family law, is split into 2 papers from the beginning. Earlier, first paper relating to matrimonial issues, marriage, divorce, adoption, maintenance, etc., in respect of Hindus, in respect of Muslims, in respect of Christians and other religions. Only matrimonial issues is paper 1. And for Hindus, Muslims, all religions. Same concepts, different religions, paper 1. And paper 2, only succession issues and property. If a person dies, how the property will go to his natural, his legal heirs. That is succession. In the sense, what is the Hindu succession, Muslim law of inheritance, testament law of Muslims, all these things. Succession, there are 2 categories: intestate succession, testamentary succession. If a person died without leaving a will, as per rules of law, the property will be distributed. These aspects we have to discuss. So, let me tell you, first of all, in this particular lecture, I deal with 2 topics: family law 1 and 2. Second one is law and various kinds and classification of law. Thirdly, legal studies and legal profession, the prospects of legal studies and legal profession. How far our legal profession is enjoying so many privileges and great social status. So now coming to the family law 1 and 2. So that is why the family law may be the classification of syllabus varies from university to universities. Some universities prescribe 2 papers of family law. One is family law 1, it may be Hindu law. The other is Muslim law, Mohammedan law, it may be family law 2. So, if it is the title is Hindu law, in that particular subject, marriage, all matrimonial issues like marriage, divorce, adoption, maintenance, minority guardianship, plus succession, in testamentary succession and intestate succession are studied. If it is Mohammedan law or Muslim law, all issues, marriage, divorce, matrimonial reliefs, mahar, triple talaq, succession in the Muslim law of inheritance, Muslim testamentary succession, wills or wasiat, these aspects you will study. That is Hindu law 1 paper, Mohammedan law 1 paper. Hindu law as a whole means matrimonial issues plus succession issues. Mohammedan law means matrimonial matters and succession matters are studied. Or otherwise, in some universities, the concepts are studied for all religions, Hindu, Muslims, Christians, and other religions, Jews like that. Some other religion, marriage, divorce, adoption, maintenance, minority, guardianship, succession, law for intestate succession, testimony and succession, all these aspects are studied. That is why, because of this conflict of arrangement in syllabi, I would not able to upload important questions and how to answer in respect of family law 1. After completing this family law 1 and 2, all the aspects, I will give you enactment wise Hindu Marriage Act, what topics are to be studied first. Muslim law of inheritance, Muslim law of marriage, matrimonial issues, what topics are to be concentrated first. Hindu succession, what topics are to be concentrated first. Muslim law of inheritance, say testament succession or Muslim wills, how, what topics are to be taken up first. I will discuss. Then I covered Hindu Marriage Act, beginning to ending. In that, I suggest you to study first Hindu marriage meaning. Hindu for common sense purpose. Who is Hindu? You have to study. Sometimes short notes may be asked. Secondly, marriage conditions of 5, section 5 you have to read. Then nature of Hindu marriage, whether it is a sacrament and sacrosanct or civil contract or both sacrament and sacrosanct, that topic you have to study. Then immediately you should go to section 9, restitution of conjugal rights. Immediately then you go to 13b, divorce for mutual consent. Then you come to 10 and 13, the grounds are common. Section 10, judicial separation, 13. So other things tentatively you have to follow. Then you follow 11 and 12, nullity and alignment of marriage. Thereafter, as per that, you have to follow that. So this is Hindu Marriage Act, important topics in order of priority, I have told you now. Then in matrimonial issues, what is marriage, what is divorce, what is adoption, what is maintenance, what is minority, what is guardianship, all these things in Hindu Marriage Act I enlightened you in detail, but subject to certain changes and methodology. So the topics will be same in almost all religion, but the topics are same. The way in which they follow in the respective religions will be different. What I am going to enlighten you in detail in the subsequent chapters. You have to keep it in mind. Regarding succession means it is inevitable that every human being will die one day or other. When once a person dies, the property goes to the legal heirs. If legal heirs are not there, the property goes to the government and the estate of asset is what I will explain in detail. Suppose when a property is, when a movable property is transferred from one living person to another living person, that is goods, commodities, TV, radio, cars, all these things transferred from one person to another person, the law applied is Sale of Goods Act. When immovable property is transferred from one living person to another living person, the law applied is Transfer of Property Act 1882. When property, movable or immovable, is transferred from one dead person to living persons, that is illegal heirs, that is sons and other relatives, sons, wife, children, grandchildren, brothers, sisters, father, and so on. All these are near and dear. So, how the property? If a dead person dies without writing will, without writing any testate, that is called the intestate succession. Intestate, intestate, intestate means intestate or clubbed, means without testate. If a person died without writing any will, the property goes to legal heir as per rules. In Hindu law, class 1 heirs, class 2 heirs, how if a woman dies, how the property will be distributed like this. After the Hindu Succession 2005 Amendment Act, the position of male and female is made equal. So woman is a man for all, for the purpose of property. Woman earlier only males were co-partners. After 2005 Amendment Act, females also are co-partners. They get rights on par with the wife and daughters. Will get equal rights in joint family property. In joint family property, that is the position. This aspect in joint family I will explain. For the to the effect, the concept of pious obligation also was abolished, because the son's duty to clear the debts of father or father. Son, so what is the position of son? What is the position of the grandson? What is the position of great grandson? Son, principal plus interest. Grandson, only principal. Great grandson, to the extent of his share in joint family property. All these aspects were there. That this pious obligation is abolished. However, we will have to discuss about this topic in joint family, which I will take up in due course. So this is, if the dead person did not write any will, did not write any testament, the property goes as per rules. In Hindu law, class 1 heirs, class 2 heirs, agnates, cognates. If nobody is there, the property will go to government under estate. Then if in Muslims, if in Hindu law, if the Hindu male or female, they have written a will, according to the contents of will, the property will be disputed. If the one can write will, if it is his own property, self-acquired property, for ancestral property he should not get. These details I will explain in later. But if he is written will as per testate, as per testament, as per will, the property will be distributed. Suppose the male has a own property, self-acquired property, he can write will to anybody, in unrelated person, friend or relative, distant relative, or some old age home, whatever it may be, nobody can question. That is will. If will is not there, as per rules. If will is there, testament section. Will is not there, intestate succession. These rules we will have to discuss. Male intestate, female intestate, Hindu will, what are the consequences of the will, all these things we did. Similarly, in Muslim law also, marriage, divorce, dowry is there, one important topic, mahar or dower. Secondly, Muslim wills are there for succession. Muslim intestate section. Muslim intestate section are in a Muslim law of inheritance, that is sharers, residuaries. There will be the property in case of Muslim law. If a Muslim died without writing any will, the property will go as per rules. That is the sharers, first class heirs, say residuaries, second class heirs, and distant kindreds. In the absence of sharers and residuaries, the property will go to distant kindred. For that, there will be some Muslim tables are there. As per the table, it will be there. If the property is remaining, the principles of the doctrine of foul and doctrine of Radd will follow. What is these doctrines of foul? What is this doctrine of Radd? I will take up in the next topic. Another point is the Hindu joint family. In Hindu joint family, there is a topic. Hindu joint family property is there. Co-partnery, and within the co-partnery was there. And next partition is there. Karta is there. Karta, the manager, his powers and functions are there. After the passing of the Hindu Succession Amendment Act 2005, so many drastic changes, sweeping changes took place in this area. What are those changes brought about under the 2005 Succession Amendment Act? I will enlighten you in brief, dear friend. These are the various issues. That is because of this matrimonial issue and succession aspect for different religions. Either Muslim law, religion, in the Muslim law, Hindu law is having as great important in succession law. That is why Hindu law and Muslim law is there. But the other laws, they are minorities. That is Muslims in India. Muslim community is minority community. In some countries, Muslim community is majority community. That is why Muslim law and Hindu law are titled. So these aspects, dear friend, I will explain in the course of time, one by one, very clearly. Next one is law, kinds of law, and different kinds and branches of law. So actually, law is an instrument to regulate human conduct. The law is an instrument to regulate human conduct. If people, every human being, knowingly or unknowingly, intentionally or unintentionally, voluntarily or deliberately, commit certain wrongs. Wrongs in the sense, what acts he is not supposed to do, he commit. What acts he has to do, he did not do. Such act or omission which result in wrong. If the wrong is of less serious nature, it is normally titled as tort. If the wrong resulted is of a serious nature, it is titled as crime or offense. In sometimes the position will be vice versa, what I explained in detail in previous lectures. So the law is basically, we are doing how we are able to do what is good, what is bad. It is because of Dharma Shastras, Shrutis. Shruti, Shruti is what God said. That is good, this is bad today. Why? A mother and son should not get married. Why? Because how we know? Because of parents we lost. He lost parents means from Dharma Sutras. How these Dharma Sutras are made in a Manusmriti and Narada, Yajnavalkya, so many things are there. Sutrakars are there. The Sutrakars embedded texts, Sutras, Dharma Sutras in text, and all these things. From these natural law, divine law, everything is there. So the act of God, the voice of God is more than the voice of the king or voice of the crown. So the king is below the voice of the God. God is superior to everything. The act of the word of God is final. So this is good, that is bad. God said to Rishis like Vishwamitra, Vashishta, Valmiki, such some sages. Those sages communicated this matter to human beings. What the direct speech between God and sages is Shruti. From the what is communicated from sages to human beings is called Smruti. Those Smrutis are embedded in a text called Dharma Sutra, embedded in a text called Manusmriti and others. And those rules embedded in this Manusmriti and they are called Dharma Sutras. Dharma Sutras. So these Dharma Sutras, these are the Dharma Sutras. So that is why in Hindu law and Muslim law, prior to passing of the Indian Penal Code 1860, laws are civil laws are different. Civil laws are, criminal law is common to Hindus and Muslims. Today we have separate laws. Civil law is separate, criminal law is separate, and in civil law, personal laws are different to Muslims, Christians, Hindus, different. But before passing of Indian Penal Code, that is 1960, during British rule of 350 years, 1600 to 1950, Hindus were tried according to Hindus' personal law, that is Shastras. These Shastras came from Dharma Sutras. Dharma Sutras emerged from Vedas, Rigveda, Yajurveda, Samaveda, Atharvana Veda, and so on, originated from the Shruti, like this. So, Hindus were tried according to Hindu personal law, Dharma Sutras. Muslims were tried according to their personal law, Quran, Quran is final. Quran is final. Basing on that, Muslims, this significance of Quran was critically explained in Shabanos case. In Shabanos case, that point, that item I discussed in maintenance topic. So here, before, Hindus were tried according to Hindus personal law, Shastras. Muslims were tried according to Muslim personal law, Quran. But criminal law was tried. Hindus, Muslims, and all communities were tried according to Mohammedan criminal law. In those days, Mohammedan criminal law alone was there. But there are so many defects in Mohammedan criminal law with reference to kinds of punishment, with reference to law of evidence, ill treatment, discrimination. So many irregularities are there. That's what I explained in the defects in Mohammedan criminal law while teaching this. Uploaded in Indian Penal Code, kinds of punishment and everything, dear friend. So after passing for Indian Penal Code, yeah, all residents of country, all inhabitants in India are tried according to Indian Penal Code. All religions, Hindu, Muslim, Christian, Buddhist, Jews, all people, all citizens and non-citizens are tried according to Indian Penal Code for criminal matters, offences. But civil cases, so far as civil personal law is concerned, Hindus are tried according to Hindus personal law, Muslims are tried according to Muslims personal law, Christians are tried according to Muslim personal law, Special Marriage Act, and Jews are tried according to their personal law. For personal law means marriage, matrimonial issues, marriage, divorce, adoption, maintenance, minority, guardianship, and succession matter. They are called personal laws or matrimonial laws. This is with reference. Now coming to the law, in law there is a natural law or principles of equity. We law means what is as per dharma sutras, the principles of morality. The main object is to give judgment impartially without any discrimination on the ground of sex, race, religion, or anything. That is principles of equity. The principles of equity or natural justice were followed by High Court of Chancery in England. That's what we followed now even today under the principles of justice, equity, and good conscience. When the judge, while deciding the case, finds that whatever he finds good in the light of the principles of natural justice, that is justice, equity, and good conscience, he does not take into consideration, he would not take into consideration custom, legislation, everything, and he will follow the principle of equity or justice, equity, and good conscience, and he will deliver the judgment exercising his discretionary power or inherent jurisdiction conferred under different provisions of constitution for in High Court and High Court, Supreme Court level, and CPC and CRPC provisions in subordinate court level. Whatever the judge finds justice, genuine, correct, impartial, then he will give the judgment. This is otherwise known as judicial activism, and in judicial activism, judicial review classes for constitution law. I explained all these points in detail, dear friends. So that is. Then common law. Common law means during common law mean in British period in England, the judges, if law is not available to decide a particular case, because in spite of innumerable number of laws, the law thousands in number, they still some areas there is no law. In some areas, if there is law, there is not, the law is not clear. For example, when government is liable, when government is not liable, there is no any Government Liability Act passed in India, but the Crown Proceedings Act was passed in India, in England long back. There is no law today. That is why in Kasturilal and subsequent cases, so many problems took place. In order to protect, the courts are protecting the interest of the states, following the 1860s sovereign non-sovereign dichotomy. Sovereign non-sovereign, all these issues I explained in sovereign non-sovereign dichotomy, government liability, dear friends. And now that is the second one is common law. In common law in England, if the judges, even Lok Sabha members, Rajya Sabha, like Lok Sabha member, Rajya Sabha member, like House of Lords, House of Commons in England, they used to decide the case as sometimes if law is not available, they decided the case creating, coining, inventing a new principle of law. Like that, in Rallens versus Fletcher case, the principle of strict liability was coined. Basing on that principle of strict liability, in 1986, our Chief Justice of India, then our Chief Justice of India, P.N. Bhagwati, coined the principle of absolute liability in MC Mehta vs Union of India case, which was reported 1 year after the Bhopal gas tragedy case. Bhopal gas tragedy case. So this is the another part. So the law passed by the judges to deliver pure and impartial justice, either due to the reason there is no law. If law is there, law is not clear. If there is neither law nor unclear law, if he creates a law of his own to deliver correct, pure, impartial justice, that law is called judgment law. This judgment law in common law courts in England is called common law. That type of new law can be made in India also by the judges of the apex court, as in the case of principle of absolute liability coined by P.N. Bhagwati in MC Mehta vs Union of India. So this is the law. So like this, common law is there. Precedent, judicial precedent. Judicial precedent means if suppose so many cases are reported from lowest court to the highest court, that is apex court, and so many cases are identical. Suppose the Supreme Court has given a judgment in a particular case, in similar case, facts and circumstances take place in a case being tried before High Court, and the whatever judgment was given by the Supreme Court under the similar facts and circumstances, the judgment given by Superior Court earlier is followed in a cases by similar facts and circumstances. The earlier judgment is called judicial precedent. So the rule followed by some superior court in a particular case, that rule also is followed here, that the rule of the earlier superior court is called judicial precedent. That is also can be treated as one source of law. That is, judicial precedent also is a particular kind of law. So here, like this, customary law. Customary law in the sense, you children, there are some practical practices. There are some traditional practices. There are traditional practices. They are acknowledged with utmost respect. So for example, section 5 Hindu Marriage Act tells that degrees of prohibited relationship, marriage between certain relations, namely mother and son, father and daughter, brother, sister, and so on, should not be solemnized, because marriage between such two relations is very bad. It is an offense, like this. So that is what we are following. So that is following. However, some in South India, marrying one's own sister's daughter is allowed. That is custom. Suppose a South Indian, if a marriage is solemnized between any relations within the meaning of section degrees of prohibited relationship under section 5 of Hindu Marriage Act, that marriage is void. But if this custom permits, this customary law is acknowledged. So in South India, a man can marry his own sister's daughter. That marriage, if that marriage is challenged, saying that it is in violation of degrees of prohibited relationship, that marriage will be valid. The court will decide that particular marriage is valid. But in that particular case, the court has given importance to custom outweighing the legislation, principle of legislation. So sometimes custom is one source of law. So these are the that is called customary law. This customary law is there in international level also, that is customary international law. So these are the different kinds of ways of law. the different various means of laws. So these basing on this, the law is categorized in different categories. Number one is international law, then territorial wise. First one is international law, second one is national law or municipal law or domestic law, third one is public law, fourth one is public law, and then special legislations, local legislation, and so on. Now, coming to these are all important points you have to keep in mind as a law student and lawyer. You are expected to know. If you don't have these things, if you question about these in practice, the people, your colleagues in court will laugh at you. So that's why I'm telling all these things. Public international law. Public international law is two categories. One is public international law is two categories. One is public international law. Second one is private international law. Public international law relates to public matter. Private international law relates to private matters. What is public in public international law? You study about the relations between various countries, the relations between the subjects of international law. State in India is in international law. India is called state, America is called state, Canada is called state. State doesn't mean Andhra Pradesh or Madhya Pradesh, but state means in the law of nation, in public international law or law of nations, every country is termed as a state. And so this international law of states, they deals with the relations between subjects of state. State means country is a subject, individuals in that country is a subject, and territories in that country as a subject, and the bilateral treaties means agreement between two countries is called by treaty. In contract, agreement between two persons is called contract. In the agreement between two countries called treaty. The treaty may be unilateral treaty, bilateral treaty, multilateral treaty, and the interest of so many countries is discussed about the seabed resources. The United Nations Conference on Law of the Sea and subsequent developments is there, and that airspace regulations are there, outer space regulations are there, and so many issues are there. Suppose the flights of neighboring country to fly over our country, some rules and regulations are there. So airspace and hijacking, all these things are there. For all these issues are taught in public international law. So that there is an international community headed by UN General Assembly. The Security Council is there, and allied organs of international community are there, International Code of Justice, Security Council, and all these things are there. You are going to study in public international law. In private international law, in the sense, in private international law, suppose the issues relating to marriage, divorce, adoption, maintenance, succession, any movable property, immovable property, adoption, maintenance, minority, guardianship, all these things take place within the country. The national law is followed. The national law, like Hindu law or Muslim law, Hindu succession or Muslim succession, Christian law, whatever it may be, within the country, if the parties to the dispute to belong to same country, the dispute take place within the same court within the country, then the national law will apply. Otherwise, sometimes what happened is the problems relating to marriage, divorce, adoption, maintenance, and all take place in global level. In that case, in any particular case, any foreign element is involved. Foreign element is involved means involvement of two international laws is involved. Then the question of private international law will come into picture. For example, an unmarried Indian, went to America. There he got married to some English girl. then American girl. After some time, they went to Germany. There they took divorce. Then one boy, the boy go to some other country, UK. Girl go to some other country, Canada, like this. So in the process of they go to different country, they change different spouses. But in some countries, man changes many wives, woman changes many wives. The concept of step brother, step sister, step wife, step husband, they are quite the incidence is obvious in some countries. In such a case, the validity of marriage, the validity of legitimacy of children, inheritance rights, matrimonial rights, divorce, adoption, all these issues will come into picture in one particular case. The which law will have to be followed will come into picture. All these aspects are being taught in private international law. Private international law is a very big subject. It covers so many aspects. I have written a book on private international law also, dear friends. So now, next one is the second category is national law or constitutional law or domestic law. Every country will have the supreme law of the land. That is the authority, the highest head of the law. Law of the laws. That law is called constitutional law or national law or domestic law or municipal law. This is so whatever provisions are there, whatever rules and regulations are embedded in that particular supreme law of the land, that is constitutional law, all the governmental machinery, army, navy, air force, army, navy, air force, executive, legislature, judiciary, citizens' rights, fundamental rights, directive principles, all have to be center state relation, everything will have to be designed according to the provisions of that constitution. So if the parliament has to pass law, the law should be passed according to constitutional provisions. If executive is to function, the executive, that is prime minister, cabinet, council of ministers headed by prime minister, council of ministers headed by chief minister, at the central level, followed by governor, followed by president, must function according to the provisions of the constitution. Elections must take place according to the constitution. Everything. So the laws, if any parliament pass law, all laws must be according to constitution. If parliament cannot pass all the laws, it delegates power to the executive, that is governor of the states and union and territories. Then they will pass the laws of their own, but the laws must be according to parliament law and constitution. If state in return give delegated legislation to local authorities like municipal corporation, companies, etc., they must pass laws according to provincial laws or state laws or according to parliament law and this thing. If any conflict is there, it amounts to violation or it abridges the superior law, and that particular law will be declared void, null and void, or declared unconstitutional. So this is what is called constitutional law or national law or municipal law or domestic law is national law. And contemporary to this is administrative law. Public international law is the public law. Number one, international laws, private and public. And secondly, constitutional law, national law, domestic law, or municipal law, all are same. And from this, administrative law is amended. In India, sorry, just a lot of time is there. In India, there are so many branches of law. There are in India, there are the number of cases are innumerable. 5 crore cases are pending long back. But in order to dispose of the cases, some because number of courts are limited, judges are limited. That is why some judicial powers are given to executives. Suppose the case is to be tried by the judge, but some powers, first class basis powers are given to district collector, inspector general of police to decide some cases. Some judicial powers are given to commissioners of labor commissioners. like this, like this. So the executives who are not law graduates nor late judges, they are given power to decide the cases, to put down the to workload of pending cases. So when these executive officials decide the cases through tribunals, law adalats, family law courts, fast track courts, and all, when they commit any irregularity wrong, it is to be checked. That in order to check the irregular judgment, arbitrary decisions given by the executive judges, then it will be tried by the tribunals, and it will go ultimately to High Court and Supreme Court in order to regulate the judgments of decisions given by the administrative heads, non-judicial bodies. To study all this, the subject is introduced, that is administrative law. There are so many concepts of administrative law were in earlier are from constitutional law only. That is why some topics in administrative law and constitutional law are common, namely public interest litigation, locus standi, writs, doctrine of separation of power, rule of law. Some topics are there, dear friend. So that is administrative law is one branch of law. Administrative law is not codified. Constitutional law is codified. Next branch of law is criminal law. Next branch of public law is criminal law. Criminal law, basically two codes are there. One is Indian Penal Code 1862 is there. 1860 it came into force from 1st January 1862. The other branch is procedural law, that is the Code of Criminal Procedure 1972. Originally the Criminal Procedure Code was passed in the year 1898 and recodified in the year 1973. So that is why the Indian Penal Code deals with substantive law. It defines offences, it prescribes punishment. How it become a murder, how it comes, how we can decide that it is a murder, rape, kidnap, that procedure, entire procedure, criminal procedure code decides. So these are the IPC, CRPC are the main codes of general law. They are the laws, the criminal codes in general applicable to India as a whole. But in order to speed up the cases, criminal cases, so many special courts are constituted, so many special laws are there. For example, Dowry Prohibition Act is there, the Prevention of Corruption Act is there, Forgery Act is there, Atrocities Against SC/ST Act is there, Prohibition of Atrocities Against SC/ST Act is there, Untouchability Act is there. So many acts are there. For the concerned for these special acts, special courts are also there. To apply the principles of Dowry Prohibition Act, if instead of going to matrimonial crime, if instead of going to district court and waiting for long time, if the case is filed in family court and the principles of Dowry Prohibition Act are applied, the case can be decided very quickly. The purpose of special legislation is to the special legislations and the special courts are designed to speed up the cases for specific areas and specific purpose and specific jurisdiction only. Like what fast track courts are there, so many special legislations, special courts are there. The legislations are innumerable. Those legislations are innumerable. So now here that is special laws are there. In addition to that, local laws are there. If any particular event takes place, some special act also enactment, and this suppose some crime takes place, POCSO Act, prevention of offences against prevention of protection of children against Sexual Offence Act 2002 is there. So many acts are there to eradicate the incidents of crime and to decide the cases very quickly. These are the various laws and various purposes. And civil cases are tried in civil courts. All civil matters are tried in civil court. Contractual matters relating to contract, matters relating to property, movable property, immovable property, and all these cases are tried in this thing. These are all public laws. Now private laws means contracts, Transfer of Property Act, Company Law, and all these are private. So the public act also, environmental law also come within the meaning of public law. In environmental law there are more than 212 legislation. Practically we study only 14 legislation. Environmental law is not codified as a whole, but there are 214 special legislation. And this environmental gradation was visualized for the first time in 1970. All these aspects I taught in, I authored a book on environmental law. Environmental law also comes under public law, and there's so many local laws, land sealing laws, the Apartments Act, Rent Control Act, all these come within the purview of these public laws. Next, these are the various branches of law. So now another thing is, these are the various branches of law for your information. So here, coming to the point, in there are innumerable number of laws. There are innumerable number of laws. What are these innumerable number of laws? Different statistics reveal different. The different statistics reveal different figures. What are they? So then some survey reveals there are more than 13 and 40 legislation. Some the Indian judicial system, there are about 1248 legislations. When the Ministry of the Legislative Department, Ministry of Law, as on July 2022 tells that there are 839 central legislation that is passed by Indian Parliament. Traditionally speaking, the laws are counted to on Google. In one information is there are about 6,675 legislations. Coming to the position, 3rd January 2023, 3rd January 2023, in Parliament, 176 legislations were repealed, old, outdated, useless, stale. Suppose when you work in garden, all rose flowers, jasmine plants are there, some waste, unwanted small plants are there, we pluck out and throw them out like this. 176 legislations were repealed abolished in last year, that is January to 2023 to 31st December 2023. Our government, central government, abolished, repealed 176 legislation. It introduced 41 legislation, and it introduced 41 legislation, and 49 bills. 49 bills were passed. So 41 bills to propose law were introduced in Lok Sabha, Rajya Sabha in last year 2023, and 49 bills were approved. 49 bills were approved. Our Indian Parliament abolished since 2014 1,562 old legislation, old, unwanted, useless legislation. Since 2014, 1562 legislation, 1562 legislation were abolished. In last year, they include last year 1676 legislation were abolished. Last year, 41 bills were introduced. Criminal amendment bills were introduced. True, criminal law 1 in August, criminal law 3, criminal law bills to replace IPC, CRPC evidence introduced. By making some changes, these 3 bills, to withdraw these 3 bills, new bills were introduced in November. Now these 3, that is IPC, the second bills, Bharatiya Nyaya Sanhita second bill, 2023 bills are this. So there are 229 bills are pending there, but in Parliament there are 229 bills. So what is the number of legislations? It is very difficult to know. In a central level, there are innumerable legislations. The Parliament cannot pass all the laws. It gives power to the executive. The executive, that is governor, is given power to make the laws of their own. With the delegated legislation power, the states are passing their laws. But these states are giving delegated legislative power to the local authorities to make the law. So if we count so many things in state level also, some 20 in 2021, yeah, in average all states passed 21 legislations. Karnataka government passed 48 legislations. Like that, so central parliament passes laws, state legislatures passes laws. The number of laws are innumerable. That is why, dear friends, why I am telling all these things, that you need not worry about these innumerable number of legislation. When as a law student, at that time we studied 18 19 subjects. Subsequently in 2000 academic year, 28 subjects, and now there are 30 subjects. Two or three elective subjects are there. Out of these 30 subjects, as on today, the maximum number of legislations will not exceed 30 to 40. You need not go through all these legislation. You need not know all these things. Whether you become a lawyer or judge or whatsoever may be, when you become a lawyer, you will concentrate on that particular area. When you become a judge, you will concentrate on that particular area only. You need not bother about innumerable number of laws, is what I would like to tell you, dear friends. So now coming to the next issue. Next, here, even though there are so many 229 bills are pending, and labor codes, so 25 29 labor legislations were clubbed into four labor codes. They were introduced in Lok Sabha in 2019, but they have not yet become law. And however, retired members, old MLAs, MPs, pension bill. Earlier, the rule was why the MLA or MP to get pension, he should serve 5 years minimum term. That to any term he is eligible for that bill. It was passed very quickly. Like that, there one bill conferring great respect on women on the pretext of yatra naryastu pujyante ramante tatra devata. Where women are there, where women are respected, the god, women are goddess, deities, deities feel great pleasure. That is what is called, wherever women are respected, the god, goddess, and the deities will feel very happy. That is the Sanskrit quotation. So where women are respected, there the god, goddess, deities feel very happy. On this pretext, Nari Shakti Vandan Abhinayam, Abhinayam, a Constitution 108, Constitution 128 Amendment Bill. The Constitution 128 Amendment Bill was introduced in 2023, September 19. September 19. On 9th, so the Indian new Parliament Bhavan was inaugurated on 23rd May 2023. On 19th September, woman bill called Nari Shakti Vandan Abhinayam. According to this bill was passed on 19th September. It was passed by both houses and assented by the President of India. After ratification from all the states, it will be clear. For next elections, the contents of the act will be fructified. According to this women's bill, the all women are entitled to 23% reservation in Lok Sabha elections, and also assemblies of states and union territories. There are 28 states and 8 union territories. The assemblies of 36 state assemblies, the woman will represent 1/3 of the assembly. Then again, in a general quota also, woman can contest. So there will be 1/3, mean 33% woman reservation bill has been passed. It will be fructified in near future. For this ensuing elections, this bill will not be worked out, and from next bill it will be fructified. So if the government thinks over within fortnight a bill can be passed into law and gazette notification done. If it is not possible, the government may not be in a position to pass the bill and give gazette notification even for years and decade. That is the position. Like finally, dear friends, I want to tell you the significance, importance, and greatness of our great legal profession. So, dear friends, any parent or any individual will be very happy having got selected for prestigious courses like national level engineering, national level MBA, national level this thing. The so-called MBA, if any candidate getting free seat in MBA in medicine, MBBS seat or postgraduate medicine seat, getting through CA, ICWA, ACS, getting seat in Indian MBA in national institutions, getting seat in engineering seat in national institutions, IIT, Kharagpur, Kanpur, and other great institutions. It's not so easy. Only the highly meritorious who prosecuted their studies in prestigious global schools and international schools compete for that and get through. And those so-called toppers, MTech, engineering, medical, and all, compete for civil services, UPSC civil service examination, which has been acknowledged as the most prestigious and superior competitive examination. Once a person is selected for IAS, he is appreciated like anything. He enjoys great respect, privilege, and honor in the society. Even the near and dear also will feel proud of him or her. That is the social status being enjoyed by UPS service. However, whereas law is concerned, some people who are judges or lawyers, they wanted to make their successor. They put their word, boy or girl, son or daughter, in law. But in so many cases, the students who could not get in medical engineering and other courses of greater prospectus joined law. Some joined law without any interest only, because as he could not get set any seat, he invariably helplessly joined law. Like that, people, some students feel. Dear friend, don't get disappointed. Your school law course is no way inferior or inferior to any other so-called greatest course. If you make use of your law degree with your consistent stinted and unstinted efforts, you will be able to flourish like anything. You will stand superior to so-called the civil services declared candidate. Take the case. The reason is, suppose if to become civil services, every graduate of all disciplines, so BA, BCom, BSc, engineering, medical, all are eligible. But IIT, MTech, IIT, National Institute people will appear for IAS. And so the area of competition is very wide, 360 degrees. 360 degrees competition. All graduates and postgraduates compete for union public services, that is IAS, IPS, etc. But for law, very limited law candidates only compete for this. So when after law, if you successfully get through civil jet, you will get by birth. In the beginning, you get first class magistrate power. The so-called collector gets first class magistrate power. The highest officer of Inspector General of Police or Director General of Police will have the power of district magistrate, and that power is equal to first class magistrate. A law graduate after LLB, after becoming civil judge, will get that post. Similarly, whether if civil service after IAS, that the IAS candidate will join as, I'm speaking about the top post. IAS candidate will join as assistant collector in collector office or sub collector in subdivision. But he will retire as chief secretary at state level or cabinet secretary at central level. Still, he is subordinate to minister, chief minister, central minister, prime minister, etc. But if this judge retires as chief justice, either civil judge he can retire, again join. After some time he will become the district judge. After the district judge he can go become high court judge, supreme court judge, and chief justice of India. So one can become district judge directly, We have by 7 years standing, 7 years practice, direct district judge, or as a district judge directly, he can with a requisite experience, he can become high court judge like that. If the candidate with 10 years standing, 10 years standing in high court, he is eligible for high court judge directly, supreme court judge directly, but the high court judge, so here the chief secretary at state level or central cabinet secretary at central level is subordinate. But the Chief Justice of India is not subordinate to anybody, not about to anybody. He is privileged to conduct the oath of office of President of India. If any delay for mercy petition for commutation of death sentence into life imprisonment, that will come back to Supreme Court, and the Supreme Court will commute the death sentence into life imprisonment. That power is there. Any executive action, legislative action passed by states or center can be set aside by the High Court judge or Supreme Court judge. The president rule passed by president, promulgated by president on the recommendation of president, on the recommendation of prime minister in council of minister, can be set aside by the high court judge. The one high court judge, Allahabad High Court Judge Jagmohan Sinha, changed the political career of the then Queen of India, Mrs. Indira Gandhi. Subsequent developments I told you in previous cases. That is the greatness of High Court judge. So whatever it may be, so this judicial officer can order and summon these IAS officers, but IAS officers also, even High Court judge is far superior to, in Google also it is there, High Court judge is far superior to topmost officials of civil service. What a great supremacy conferred on our law people. So what are the candidates appearing for civil services? Highly intellectual, most brilliants are appearing for civil service and becoming collectors and these things. So I made a practical inquiry. Some said that some expressed IAS has a good charm. Some said no. In civil service, the IAS officer will enjoy heavenly comforts and great status as a collector only. When once he is transferred to other departments as director or something, he won't enjoy that privileges and status, is what I heard also. So this is why, dear friend, we are in law, the highly meritorious candidates studied in global school, international schools also are studying law, and yes, the average students with 45-50% also are joining law. But at the time of joining, they may be poor in study. In course of time, they can acquire more and more knowledge and become a wonderful lawman. And there were many lawyers and judges who are very average at the LLB level. Subsequently, they developed their standard and knowledge, and they become great judges and great lawyers and great legal distinguished members of legal fraternity. So whether you study in get your LLB degree from a national law school or ordinary unaided law college, but you will be eligible to enroll yourself as a lawyer, and you will become, suppose if a parent, if son tells daddy, I got selected for civil service and IAS and district judge, because 22 years LLB will be completed, 7 years standing, 29 years, 30 years and around 30 and above are eligible for both district judge and district judge and civil services also. If a candidate gets selection for IAS and district judge, he may, if he prefers district judge, there is a chance to become Chief Justice of India. But here the chance is up to Cabinet Secretary at Center and Chief Secretary at State. This is the position. So this is why in Google also it is made it very clear, the High Court judges are far superior to civil servants, that is in given in Google also, and in High Court judges, even executive action passed by a Council of Ministers headed by Chief Minister, Council of Ministers headed by Prime Minister can be set aside by High Court judge or Supreme Court judge. The President rule passed by this thing, SR Bommai case, the Supreme Court gave a lot of clarifications. If you want, you can see. Such a greatness is conferred on IAS. So don't think that it is only the candidate who studied in in one Maharashtra University, one medical college, 600 plus candidate appears for civil services. More than 106 or 107 got selected. They are all postgraduate medicals. So what is the to get MBBS seat very difficult, very difficult. To get postgrad in law is postgrad in medical is very difficult. The competition will be the huge money what you can detect. That is why, dear friends, I sincerely suggest you, if you respect Raga Suryara, if you trust his lectures, you follow my lectures in YouTube, and then go to college regularly, and what lecture I tell in 1 hour, the concerned teacher will teach elaborately in 4 5 classes or even more than that, and you learn that, you complete your subject as early as possible, you learn all the class, you attend all the classes, and you attend all the videos of Rega Suryara and attend classes, and then after your LLB is completed, you enroll yourself as an advocate and start your professional career in High Court. In a High Court headquarter, in High Court headquarter is normally a city like Vijayawada, Hyderabad, Bombay, Delhi, Calcutta. There will be number of competitive examination center. If you join competitive exam center simultaneously to take coaching for civil judges and district judges exam, in competitive exam centers there will be lot of competition among the candidates taking coaching, because after lunch hour or dinner hour they sit together and they conduct quiz competition, then we'll ask question. When you see the knowledge of the other candidates, you will automatically get lot of inspiration spirit. So they are reading, the others are reading very well, they have very good knowledge, I don't have that much knowledge, I too must compete with him tomorrow, I too must work day and night, and that. So in college level you cannot have this competitive spirit. In college education, your primary concentration on is life enjoyment, and second concentration is studies. If you join competitive exam, your primary concentration will be studies to win the post. So that is why, dear friend, you please don't underestimate our legal course. Our legal course is no way less than any other course. On the other hand, our legal course has been proved to be a greater cost, superior course in provided you work hard and you fructify the status supremacy conferred on legal profession by doing hard work. Thank you very much for your patient hearing. Dear student friend, if you want to watch my video immediately as and when you will, it is very difficult to watch a number of videos at a time. And so in average 3 days, 1 hour you sacrifice, you will be able to complete my videos. So I can tell one thing, it may be difficult for the students in general to watch my video for 1 hour, because I am helpless. Unless I take 1 hour and above, I won't be able to complete all these giant projects. That is why I am taking much time. So here you download it and share among the friends. Just though the lecture is above 1 hour, you will be able to download it within 5 minutes. So your net will not be exhausted. So that is why I don't want you to go for more views and everything. You download it and share it to many, and if maximum number of students utilize my lecture, I can have more and more inspiration to deliver more and more lectures. I sincerely promise you, if you help me to help you by utilizing this, I will try my level best to upload the lectures on for judicial service, including even district judge also having an inclination to that effect. I am making enquiries, the question papers and all and pattern. So I will do my best. So because I am not doing any job, but I want to I want to spare all my time for this purpose. Please take our law course very serious and work hard. God bless you. All the best.